At this time, I'd like to reserve 2 minutes for rebuttal.
All right, 2 minutes.
So before I begin, I'm really only going to make argument on the second argument in my brief, which is that the trial court gave an erroneous jury instruction by not giving a courtesy instruction when the jury submitted their questions. And to back up, I'm just going to briefly touch on what occurred. Mr. Walker was charged with convicted for 2 counts. Criminal intent, first-degree murder, and employing a firearm during the commission of a felony. That was as charged. He was indicted on those 2 counts and convicted as charged. Shortly after closing arguments were had and the jury began deliberating, the jury came back and submitted to the court a first note stating that the jury is unsure how to define judgment as it reflects to premeditation. And the Shelby County Trial Court just told them they have all their information, they need a unanimous verdict. They had a second question shortly thereafter saying if the jurors cannot agree on the first count, open pairing, guilty plea, closed pairing, must we then all agree on a unanimous not guilty plea before moving to the lesser included offense? The trial court did instruct them that their verdict must be unanimous and that they could then move to a lesser included offense. The trial court committed plain error by not giving a courtesy instruction. Of course, plain error requires a clear record of what occurred at trial. I would argue that the transcripts are clear as to what questions the jury had and how the trial court instructed them. A clear and unequivocal law was breached. This is the second portion of plain error. And here, looking at the record, it's very clear that the jury is considering a lesser included offense. They brought back, they've had questions about judgment in the definition of judgment, which could go towards mens rea. And then their second question is directly addressing whether they have to be unanimous.
What's the clear and unequivocal rule of law that's been breached?
So I would argue that with the question the jury submitted, it is very clear that they're deadlocked. They might not be saying we're deadlocked, but they are indicating that they are having trouble coming to a unanimous decision. And in Tennessee, when a jury's deadlocked, you cannot give an Allen charge, and the court did not give an Allen charge.
So this is a long way from a dynamite charge, right? Because, I mean, an Allen charge requires the court to admonish the dissenting jurors that they need to re-examine their own views, that the views of the majority need to be given weight, and that we all kind of need to come together, and minority jurors who were in the dissent, you need to get on board. And that didn't happen here, right?
And for the record, does not reflect that the court explicitly gave an Allen charge, but the court is stressing that the verdict must be unanimous.
Well, but the sequential jury instructions given at the first part of the trial also suggest that, right? You can't go to the first lesser included offense until you have resolved unanimously that he's not guilty of the charged offense, right?
Yes.
And so the unanimous portion of that verdict was already given as part of the pattern jury instructions. How did the supplemental instruction, which seemed to just repeat the pattern instruction, how did this violate a clear and unequivocal rule of law?
And I don't know if I have the best answer for that, but my argument would be that the court gave the supplemental instruction, and the jury's coming back with questions about whether they have to be unanimous. And I guess kind of the gray area I'm arguing is, are those questions an indication of a deadlock? And if it does the jury have to say out loud we're deadlocked, or if it indicates from the record that they may be deadlocked, should the trial court have to give that courtesy instruction?
So the absence of the answer to that question may weigh into the very first plain error factor, right, about what the record shows. The record doesn't clearly show that they were deadlocked. You would agree with that?
Yeah, I would have to concede that.
I mean, I know that's the interpretation, but there's nothing clearly in the record that suggests they were deadlocked.
There's, from my review of the record, that I would have to concede that. The jury never outright says we're deadlocked.
Yeah.
A substantial right of the accused was adversely affected. Obviously, in Tennessee, the accused has a right to a unanimous jury. I know that the state in their brief raised that it may have been done for tactical reasons. I understand the state's argument. I would just ask the court to look at the record. I don't think the record reflects that there's any tactical reason or that the council indicated there was a tactical reason for doing this. And the last prong, the consideration of this issue must be is necessary to do substantial justice. When I think of the rights that the citizens of the state of Tennessee are given, unanimous jury verdicts are probably at the very top. And what concerned me about this case is that the jury is having issues or expressing to the court that, for one, they're looking into judgment, which goes towards mens rea, which would indicate they're looking at lesser included offenses, and that two, they're having issues about, do we have to come to a unanimous verdict before we move on to lesser includeds? I understand the court, repeated the supplemental instruction previously, but again, I feel like it's in that gray area where it's indicating deadlock. The most prudent thing to do would be to give that courtesy instruction.
That was already given, though, as part of the original instructions? So typically, what we call the courtesy instruction is part of the pattern instructions that
Yes.
typically are given by the trial court as part of the original charge. Were they given as part of the original charge?
Courtesy was not, the Tennessee pattern instruction, I think it's like 1522. I don't believe courtesy.
It may be, but what I'm saying is in the pattern instructions,
Yes.
and I think all three of us were trial judges, but I think in the pattern instructions, they suggest you can give the courtesy charge at the beginning as part of the original charge. I always gave it as part of the original charge. Did that not happen here?
I do not think so. Now, I must confess, I did not reread the jury instructions before coming here today, but I would have reviewed those before submitting my brief.
Are they in the record?
They should be in the record, I believe. I'm not exactly sure about that either,
That's
but
fair.
Let me ask you about the
Yes.
tactical decision prong, because that kind of interests me in the context of this case. Couldn't it be that the jury asks a question like this, and the defense attorney's sitting over at the table and saying, oh boy, they're struggling over the lead charge here. And then you hear this instruction, you say, you know what? I may sit on this. They may go back there and come back with an acquittal on the lead charge and hit him on a lesser included. Isn't that a possible outcome here?
the big thing I struggle with that is what harm, I mean, I guess I do see what the court's bringing up. I guess it would just be, it would be how speculative the defense attorney is as to who they think's in the minority or the majority. I do feel like had it been a tactical decision, the defense counsel would have raised it in the motion for new trial, which they did not. It's one of those things that I understand the state's argument that it could have been a tactical decision. Let's see if they come back with a lesser included. But if you tactically do that, this issue's off the table. You're arguing it on plain error, which is a big hurdle.
Yeah,
Not totally.
But if it works, you get an attempted second instead of an attempted first. I mean, that's the definition of a tactical decision. You make a call, sometimes it works, sometimes it doesn't.
Yes, and I cannot with 100% certainty tell the court. I do not know it was a tactical decision. I'd have to know from the trial attorney, I believe. All I know is what's in the record. And so I think it would be up to the court to consider that. But
Whose burden is it to show that it was or was not a tactical decision on plain error review here?
Okay, it's the appellants.
It typically is. I mean, sometimes, and the reason I ask is because I think sometimes in our Supreme Court cases, and in our cases too, it fudges a little bit sometimes depending on the context, and I wondered about your perspective here. Do you believe it's your burden to show that it was not a tactical decision?
I did some research on the law, but I'm not exactly sure. I know, I did not think it was clear from the record, but I think showing clearly, it would be very hard for any defendant to show clearly that a decision made was not a tactical decision. I feel like you'd almost have to have like the trial counsel go under oath. I mean,
Well,
it's
you
just.
would. I mean, it'd be
Yes.
on the motion for a new trial, right?
Yes.
So you could call trial counsel on the motion for a new trial and put that evidence in the record. Was there evidence presented here on the motion for new trial?
No, the original trial attorney also did the motion for new trial. He made an argument that kind of denoted, it was more critical of what the jury was doing. It was more, the court should have declared a mistrial because the jury was asking these questions, but this was not addressed in the motion for new trial.
Okay, very good. Thank you.
And just kind of circling back, the whole reason we have curse instructions is to avoid jurors in the minority ceding their opinion to jurors in the majority. And I just think that the court, out of an abundance of caution, should have kept that in mind in giving the curse instruction. I don't believe I have anything further.
All right, thank
Thank
you,
you.
counsel.
Good morning, Your Honors. Kirby May on behalf of the state of Tennessee. We're asking Your Honors to affirm the verdict of the jury as to each count as charged, as well as affirm the ruling by the trial court in its giving of the supplemental jury instruction. And I will focus my argument based similarly to the defense as to the jury instruction question, since the defense focused on that. But if you have any questions regarding the sufficiency of the evidence, what's the state's position, it was simply overwhelming. Briefly, this is a relationship the victim, Ms. Kuykendall, had with the defendant for over 4 years, an intimate relationship that ended almost tragically on that evening, where it was ongoing from December 5th into December 6th. Over the entire evening, the defendant had numerous interactions with Mrs. Kuykendall throughout the evening and into that morning. And the testimony and the evidence is Exhibit 2, which is the video, the culmination of the events where the defendant rammed Mrs. Kuykendall's own pink car into the car that she was driving twice, stepped from the car and shot at her and striking her 7 times. She then tried to drive away. He rammed her again into oncoming traffic. She then slides over to the passenger seat of her car, sees him as his car is now disabled, starting to walk away. As her testimony is, they interacted with each other and spoke to each other, and she said, why did you shoot me? And he told her, I told you I was going to shoot you. This is a culmination of all the events. At no point did Ms. Kuykendall ever vary from her testimony or identification of the defendant as the assailant that evening, or that morning.
That's the only basis for the sufficiency challenge, as I understand it. It's just identity. Is that correct?
Yes, Mr. Greenholz, Judge Greenholz. And the point that you pointed out, that the focus of the defense's argument in that sufficiency was as to the video and the angle of the video. And you just very accurately stated in your previous oral argument here earlier today that the videos can have different perspectives than what the eyewitness, in this instance the victim, had. And she was very clear and consistently identified the defendant as her assailant. Now, getting to the supplemental jury instruction, a point the state distinguishes from the defense is that in its closing instructions to the jury, Volume 1, page 110 is the actual instruction, but actually in the instruction itself, which is Volume 3, 228 to 229, the court did give the standard Kurtz instruction where it told the jurors not to surrender their views in detail and its honest conviction.
That was part of the original charge to the jury.
Yes, it
right?
was.
Okay.
And reading into the instruction, into the interactions during deliberation, during up into and through deliberation, there were multiple questions regarding unanimous verdict, and as well as to the culmination of this question here that got us here today, where the jurors asked if we cannot agree to the first count, guilty plea, must we all then agree on unanimous, not guilty before moving on? And that's a very astute question of a jury trying to clarify the deliberative process, and must they get to a unanimous verdict? Now, could the trial court judge have pointed them directly to the previous instructions as to the deliberative process, to unanimous verdict? Yes, they could have. The judge simply paraphrased those. Now, also, you have to take into context, at no point to the defense, the state, or the court consider this to be a jury indicating that it was deadlocked. There was no discussion of that. The defense at that moment in the transcript, which is about volume 3, 257 to 259, only made a comment as, I think they're confused as unanimous verdict. And the judge then took that and gave her instructions, which are page 259 to 260, and gave that instruction that it gave. And also, it's pointed that in its motion for new trial, again, the defense only raised that the jury was confused as to unanimous verdict, and that's at volume 1, 136. And then at the motion for new trial, the defense attorney, again, volume 5, page 8 to 9, never mentioned deadlock, never mentioned that they were concerned with that, and the court never addressed that issue. So then, raised on appeal, this is for the first time that there's indication that the concern of whether it was deadlocked. And it's the state's position, there's never an indication that was deadlocked. It was just a confusion of at what point can we consider lesser includeds. And again, this is very clearly a tactical decision by the defense counsel, because again, earlier in the deliberative process, they had mentioned regarding the mens rea analysis. And now they're indicating that there's a potential that they want to consider lesser included offenses. So clearly, an astute defense attorney would let this play out. And it was a very tactical decision as to whether, see what the jury would come out with. Because there's clearly, we, as trial judges, former trial judges, and as a former prosecutor, you've seen those where the juries are mentioning and having lots of questions. That's usually bodes well for a defense attorney and a defendant. And so they allow that to play out.
So who has the burden in this case on plain error review of showing the absence of a tactical decision? Sometimes I'll see in cases where the Supreme Court will say, there's no evidence in the record that there's a tactical decision, so we're going to pass by the third factor, fourth factor maybe. Who has the burden here?
In plain error, it's the defendant's burden.
It always is, but that is true. But sometimes the Supreme Court will slide over the tactical choice factor if there's no evidence in the record that in fact it was a tactical decision. So if you're making inferences,
yes,
the appellant's making inferences about whether it's a tactical decision, who has the burden? Is it the appellant?
I would believe it's the appellant. And this, as I think my friend on the other side and Your Honor has also pointed out, that to really delve into that, the trial attorney would have to testify at a motion for new trial to really delve into that issue. But I don't think we get there, because all 5 of these plain error analysis have to come out in favor of the defense for the court to find plain error. And the state's position is that it was clear what was happening, and it was not a deadlocked jury. So thus, you don't get to the Kersey instruction, even though the court had already previously given it. And then also, you don't get to the Baxter, because the analysis under Baxter, because there's no indication of coercion or pressure put on by the court. Because even in its discussion, it said, you go to the first, and then if you find out guilty, you move on, you move on. The court also, twice in that one paragraph of the transcripts, or actually multiple pages, about 2 pages, indicates if you have further questions, come back. So there, even though it said we're here, we'll remain here, you to go deliberate, but it said it invited them, the jurors, to come back and again and question. And they clearly had asked questions before during this deliberative process. And then finally,
You say there's, I'm sorry to interrupt, but
No.
you say there's no clear indication that they were deadlocked, but it was at least hanging in their question a little bit by saying, hey, if we can't agree on count one, it had been thrown out there somewhat. And then you get this instruction. Can this instruction not be read to be maybe a little overbearing in terms of how many times the trial court says, we're looking for a verdict? We're looking for a verdict. She seems to repeat that over and over again. It has to be unanimous. We're looking for a verdict.
I think it's taken in context, because if you look at the discussion by the parties, in that it's a very, very brief discussion prior to the judge bringing the jurors in, and the court's analysis right there, the reason they kept saying verdict is because they had mentioned the term plea in their question. And I think the court was probably more emphatic that she was clearing up that there was never a plea, rather than that that's part of the context of that discussion. But it told them to go back and to continue to deliberate. I think that the verdict portion is starting from the top. You have to go from step to step in the deliberate process. And finally, the state's position, there's no necessary to do substantial justice to find plain error. The evidence in this case is absolutely overwhelming in regards to what happened that evening and who was involved and the injuries that incurred and the weapon or firearm was used. There was no dispute as to what happened there. While the defense might argue that the angle that she was sitting in the car at the moment she was being fired on, she could not see him, but she clearly saw him throughout the entire morning, evening into morning, and as well immediately thereafter. And they had the opportunity, and they did cross-examine her at length about her identification of him, and she never varied from that. And so the defense has simply failed to establish any probability that any error changed, if there was any, in the supplemental instruction, to change the outcome of the trial. And any area that here does not rise to the level to undermine the fundamental fairness of the trial. And we would ask the court to affirm the judgments of the trial court here. Thank you very much.
Thank you, counsel. All right. Mr. Rudolph?
First, I do want to apologize if I misstated the record. It's been some time since I have looked at those jury instructions. The only thing I want to just touch on, this will be very brief, is that if this court does find that the jury was deadlocked, the language in Kersey is that Kersey has to be strictly adhered to, and that trial courts should not deviate from it. I understand the proof that the state brings up, but
We've allowed deviations from the Kersey instruction before, though, haven't we? Didn't we do so in
Yes.
Shafigi?
there have been times that this court and maybe even the Tennessee Supreme Court, I have to look at my research, have allowed some exceptions, but still the language is that you are supposed to strictly adhere to it. And I would argue that that constitutes the last element of plain error. It's necessary to do substantial justice.
But I understand your friend on the other side to suggest the Kersey instruction actually was given as part of the original charge.
It was given, and I guess what I would ask is that this court find that the jury was indicating that they were deadlocked, that there was a deadlocked jury, and that the Kersey instruction was much more necessary than it was just to be charged in the initial instruction. That this is the time that the jury needs to know that jurors in the minority should not yield to jurors in the majority, that they should not make that compromise to get a unanimous verdict. I believe that's all I have. Thank you, Your Honors.
Thank you. All right. Take a break. You ready to go? Thank you, counsel. Want a break? Okay. We're going to take just a short break.
All right.